Hey, my name is Braeden Anderson. I'm a securities and corporate partner here at Gesmer Updegrove. My practice focuses on securities regulation, corporate governance, and representing companies in complex financial and compliance matters.
I'm Ibrahim Salah. I'm a litigator here at the firm. I handle business and commercial litigation, including shareholder disputes and corporate governance cases.
Today, we're breaking down an important topic that sits right at the intersection of our two practices, shareholder derivative suits.
We'll explain what they are, how they differ from other types of shareholder actions, and why they've become a driving force behind corporate governance reform in recent years.
In recent years, several large public companies have agreed to significant corporate governance reforms to resolve shareholder derivative lawsuits involving alleged leadership or oversight failures. These cases are known as shareholder derivative suits, and while they don't always make front-page news, sometimes they do, they have a huge impact on how boards operate and how companies handle risk and compliance.
A shareholder derivative suit is a lawsuit brought by a shareholder on behalf of the corporation. The idea is that the company's directors, officers, or sometimes even third parties have breached their fiduciary duties and harmed the company, but the company itself hasn't acted to address it. The shareholder steps into the company's shoes to enforce the company's rights. Any recovery or settlement goes to the corporation and not to the individual shareholder.
And that's a huge difference, right? Because from a securities class action where shareholders are suing for their own personal losses, in a derivative suit, the focus isn't on compensation, it's on fixing governance or control failures that caused the harm in the first place. And many settlements lead to corporate reforms. So that might mean stronger compliance programs. It might mean better oversight or changes in how the board evaluates certain risks and ethics.
Derivative suits are procedurally demanding. To bring one, a shareholder must have been a shareholder when the alleged misconduct occurred and must remain one throughout the case. They also have to show that they're representing the company's interests fairly. This isn't a personal dispute or a way to air grievances.
And before going to court, the shareholder generally has to make a written demand asking the board to take action. And if the board refuses, or if waiting would cause harm, the shareholder can move forward, but only after satisfying those preconditions.
Under Rule 23.1 of the Federal Rules of Civil Procedure, the complaint must describe those efforts in detail or explain why a demand would have been futile. The futility question is often where early litigation happens. Courts look closely at whether the board could have acted independently to fix the problem. If most of the directors are conflicted, demand may be excused, but if they're not, the case can be dismissed outright.
Before filing, shareholders often make what's called a books and records demand, a statutory request for internal company documents. This helps them understand what happened and, if needed, file a more informed and more credible complaint. Courts have encouraged this step because it ensures that claims are grounded in evidence, not just speculation.
Once a case is filed, the board can still move to dismiss it through a special litigation committee made up of independent directors. If that committee determines in good faith, after reasonable investigation, that the lawsuit isn't in the company's best interest, courts will usually defer to that decision. And any settlement or dismissal requires court approval with notice to the other shareholders.
From a governance perspective, these suits have become an important mechanism for reform. They're often used by institutional investors like pension funds or endowments to address weaknesses in areas like board oversight, workplace culture, cybersecurity, VEI initiatives. And unlike federal securities class actions, derivative suits aren't governed by the PSLRA. So courts look beyond who owns the most stock. They consider who can most effectively represent the company's interests in this case.
That's right. These cases can lead to real structural change, the kind that improves long-term shareholder value and helps prevent future problems. They're not about punishment. They're about restoring accountability and ensuring the company is governed responsibly.
All right, so I mean, to sum it up, a shareholder derivative suit allows shareholders to act when the company won't protect the business from harm or is failing to cause the business from harm by those who are in control.
They're complex, high-stakes cases that combine corporate governance, litigation strategy, and fiduciary law, and they can have lasting effects on how companies operate.
Thanks for watching. For more conversations about corporate governance, shareholder rights, and litigation strategy, subscribe to the Gesmer Updegrove channel.
And as always, this video is for informational purposes only, and it's not legal advice.
Thanks for watching. My name is Braeden Anderson.
And I'm Ibrahim Salah.
Talk to you very soon.